Hello, everyone. Many thanks to the organizers for your very, very kind invitation. I wish I could make my presentation in Italian, but unfortunately, I'm not competent to do so. I'm going to speak to you about a recent enactment of a new insolvency framework in Greece. And it may be of interest to you because it is one of the earlier attempts to transpose the European Directive on Restructuring into national laws. Uh, Greece has had a bankruptcy law or bankruptcy laws since its inception back in the early 19th century, but it was in 2007 that we produced our first insolvency code, the bankruptcy code, which was consistent with the tendency of the time, very debtor-friendly, and also introduced a couple of proceedings which were directed to preventive restructuring. We have a preventive restructuring proceeding in place since 2011 after an amendment of the code. And there have been different amendments of the codes between that time, 2011, and the introduction of the new insolvency scheme. Why do we have a new insolvency scheme? Because notwithstanding the efforts of the legislators throughout the 10-year economic crisis in Greece, the scheme did not prove good enough. There was an IMF report in 2017 which said the insolvency system is not able to perform its fundamental economic function, namely to offer creditors the most efficient means of recovery, which implies the preservation of viable enterprises, the liquidation of those that are not viable, and the redeployment of resources to more productive uses. So, against that background, the Greek government decided to pass a radically new insolvency law, which created a new insolvency framework, and that law was passed in 2020. Among other things, it transposed the 2019 directive on preventive restructuring. When the law was passed and when the directive was transposed, we had to take account of the local circumstances. And when I speak of local circumstances, I mean of the lack of specialized courts, the lack of insolvency knowledge amongst judges, the lack of specialized professionals, the tendency of Greek lawyers to abuse procedures, that is, when there's the opportunity of a stay of execution, that stay would be used and abused rather than promote negotiations. And generally, I would say we lack a negotiation and a recovery culture. So those were the constraints that we had to take into account when transposing the directive. As a general rule, what we try to do, and I say we because I was one of the team of experts that contributed to the drafting of the law, what we try to do is to produce something which would be procedurally very simple, streamlined, with few opportunities for abuse, and without undue sophistication. So the idea was to make it as straightforward, as predictable as possible, even at the cost of some degree of a sophisticated solution that would address difficult situations. Coming now to the specific provisions, first of all, we decided we did not need a provision, we did not need a procedure for negotiation. So what the law provides is that you have an agreement already in place, which has secured the requisite approvals, consents by creditors and debtor, and that agreement is filed for ratification by the court, by the bankruptcy court. That is fully aligned with the directive, even though the directive would also anticipate the possibility of regulating the negotiation itself. On information on creditor claims, those need to be the closest possible to the date of filing. What we have in place is a statement by an expert based on the company's books and on any recent judicial decisions, including injunctions, which on a preponderance of probabilities find that there may be a claim. And based on that information, the expert puts together a list, which must not be more than 3 months before the filing of the agreement for ratification. One of the very difficult areas which the directive introduces is that of class formation. The directive says that when you vote on a plan, when you provide consent on the plan, creditors must be grouped into classes, each of which has a degree of identity of interest amongst those creditors. But critically, the directive allows you to form just 2 classes. So in the interest of avoiding complexity and of not exposing the courts to problems of class formation that would be difficult to address, we decided to have only 2 classes. One is the class of secureds, and one is the class of everybody else. And each class must approve the agreement by 50% plus 1 share, 1 vote. Nevertheless, as we know, the directive also anticipates the possibility of cross-class crackdown, and it says specifically that at least one of the classes must approve the plan in order for it to be ratified. And so what the Greek legislator has decided is to require the approval of at least the class of secured creditors, plus the approval of 60% of creditors by value of claims, and provided that no class is worse off than it would be in the case of bankruptcy, and that no class of inferior rank gets more than a class of a superior rank, and that is a general test under the directive. No class gets more than it would than the value of its existing claims. Interestingly enough, the directive says that in the case of small enterprises, you cannot have a restructuring plan without the debtor's consent, which implies that you can have it in other cases. In our law, you can have it as basically an insolvency sale. So what you require as a prerequisite for approval of a plan where the debtor does not approve, does not consent, is cessation of payments. Now, one of the areas of concern under the directive is shareholder holdout. Shareholders are usually not in the money in cases of troubled over-indebted entities, legal entities, and therefore shareholders are often in a position of not having any economic interest in the outcome, and the value that they hold is in being able to resist the plan. That would allow them perhaps to extract some value concessions. The way we've dealt with this problem under the new law in Greece is, first of all, we place the responsibility of agreeing to a plan with the board of directors, not to shareholders. Shareholders, where the law expressly requires it, may be have the ability to approve the implementation of a plan, say when you have a debt equity swap, or in the other cases where the law requires shareholder approval as a prerequisite. And we have also provided that where the shareholders do not agree, say, a debt equity swap, but have no adverse economic impact would have had no adverse economic impact by that swap, then the creditors can apply to the competent court in order to appoint a special agent to vote the shares in favor of the plan in lieu of the shareholders. And generally, I think that we should all be looking at Article 32 of the directive, which allows for derogations from the general principles of corporate governance where required, and to the extent required, for the implementation of a restructuring plan. I should also note that the directive provides that interim and new financing should be protected. In our law, the way we've handled that is by providing that where new financing or interim financing is provided for in the restructuring agreement, and that financing is provided in the case of interim financing not earlier than 6 months prior to the filing of the agreement for ratification by court, then, regardless of whether the restructuring is approved or not, that financing enjoys what is basically a super priority. So it will be satisfied at the same level as secured financing for financings provided after the beginning of 2019, or for older financings, it will be satisfied prior to anybody else. So it gets basically the cream from any liquidation in the event of a subsequent bankruptcy. I should also mention that, as in the directive, agreements which are provided for in the restructuring agreement enjoy protection from being set aside from transaction avoidance under the bankruptcy code, as well as from being challenged as potentially fraudulent conveyance under a civil code. Another very interesting area that we should need to exploit is the issue of the duty of directors to consider the interest of creditors when a company reaches a level of likelihood of insolvency. As you recall, the directive says that a restructuring agreement should be available to an entity, to a business, when it reaches the level of likelihood of insolvency. And at the same time, there may be some kind of a shift of the fiduciary duty. That's not stated in the directive, but that has been an issue that has been considered for many years, whether at that point there should be a shift of the fiduciary duty of the board of directors, of management, to the creditors. Clearly, the directive does not go as far, but it says that the director's interest should be taken into account. We have not been able to make a specific provision reflecting that in our new law, and that is for two reasons. One, because we think that under existing case law, directors must take account of all stakeholders' interests in dealing with management of the company, and therefore in some ways it may already be there. Secondly, because if management, due to recklessness or intent, has driven the company into cessation of payments, into inability to satisfy its debts, then directors or management are liable to the creditors. So there's already a liability in place. And I should also mention that we have provided that if directors, if management delay an insolvency filing because of a bona fide effort to restructure the business, which at that point in time presumably would be primarily in the interest of creditors, then that delay does not engage their liability. So there's some allowance made for actions taken in favor of the creditor's interests, which would allow the directors, without exposure to liability, to pursue. There are several other areas of interest in the directive that we have reflected in the new insolvency law. There's been we have introduced electronic means of communication for the proceedings. In fact, a lot of the procedures sit on top of an electronic platform, which provides means of communication, provides a system to vote for creditors, say, when they decide on a sale of a business as a going concern or in other circumstances. It allows for creditors to present their claims, to object to the verification of claims by the syndic. And so generally the process makes maximum use of electronic means. And of course that will also permit the collection of statistical data, which hopefully will allow us to assess the efficiency of the system and to make amendments where due. The law also transposes the directive in terms of the regulation of the insolvency profession. For the last few years, insolvency professionals constitute a profession that has its own code of conduct. It has a degree of regulation under a committee appointed for the time being by the minister. There's a register where information on insolvency professionals is given. And I would say the major change that the new law brings is in allowing the registration of insolvency professionals for legal entities and not just individuals. So now you can appoint as a syndic a corporation, provided that it employs qualified, certified individuals. That certification is provided by means of an examination, and that that legal entity also satisfies the requirements of registration, which include things like insurance policy for third-party liability, professional liability. Last but not least, I should mention that the law includes debt discharge for individuals, be they merchants or not, or consumers. That discharge happens automatically after the passage of 3 years from the issuance of the insolvency decision, recognizing the debtor as insolvent. And the discharge concerns nearly all of the debts, except for very few debts like family maintenance obligations and certain quasi-criminal penalties which cannot be discharged. In some cases where individuals contribute significant assets to the insolvency estate, the discharge can happen in 1 year. And in any case, the creditors can object to the discharge for reasons of bad faith, failure to coordinate, to collaborate with the insolvency organs, as well as failure to disclose assets. So there are bases on which the creditors can delay or frustrate the discharge. But otherwise, the idea is that the discharge should be broadly available, and that failed businessmen or over-indebted individuals should benefit from a second opportunity, third opportunity, or how many opportunities they may require. That's all for today. It's been a pleasure. Thank you very much.